May we start?
Yes, Chief Justice. May I take this opportunity to greet the Honorable Minister, the President of the Supreme Court of Appeal, and my brother, Judge President Hendricks, there, as well as all the commissioners, all protocol observed.
Yes. Just pull the mic closer to you. The acoustics are not, maybe it's
Okay,
me,
this
but
is
the
better.
acoustics, that's better.
All right.
Thank you. JP, you were born here in well, is it in Springs?
Yes, I was born in this province in Painable Springs, and I am a victim of forced removals. From Painville, the coloureds were moved to Gelukstad, African people to Guatemala, and the Indian state in Bakerton. And my family was torn apart. Colored side of my family and the African side of my family, the other side, yeah.
You classify yourself as colored,
That is how I was classified under the apartheid system, yes.
and you speak fluent English and Afrikaans,
Yes.
but then you also speak fluent isiXhosa. How did that come about?
Yes, I speak isiXhosa, isiZulu, and isiSotho.
Is that because you're from Johannesburg, or is there any other reason? Well, I mentioned this because you speak my language better than I do, and I like to think that
Okay, thank you. That's very gratifying.
you hold a few academic qualifications. A diploma juris from the University of the Western Cape, a BA law from the University of the Western Cape, an LLB from that university, a BA honors in public administration from that university, and a master's in law from the University of Cape Town.
That is correct, Chief Justice.
Right. Did you do this in succession, consecutively in succession?
Whilst I was working, I studied part-time. I was fortunate to be in the Western Cape. Both the University of the Western Cape as well as UCT offer part-time classes. So after work, I used to go to class.
You were admitted as an attorney in 2001, but you never practiced.
I've never practiced, yes.
All right. You are one of the few judges who built their way from public service. You started out as a prosecutor. That was in 1986.
That's correct.
Then you rose to the ranks of regional court prosecutor and then went to the bench.
Yes, that's correct.
You became a district magistrate in 1992 and
That is
remained
correct.
in the magistracy until 2004.
Yes, that's correct.
You were admitted as an attorney whilst you were a magistrate.
Whilst I was a
That way.
magistrate, yes.
Were you thinking of changing direction?
Yeah, and unfortunately, fortunately, that was overtaken by events.
Yeah. So you were district magistrate, regional magistrate, and then started acting as a judge.
That is correct.
Not
Chief
where
Justice.
you're stationed now, but in another division in the Northern Cape.
In the Northern Cape.
How long did you act there?
I acted there for 3 terms. I
Between-
fortuitously met the JP during a training session, the first Equality Court training, Pepuda training. We had an integrated training session, magistrates and judges, and I was asked to perform a task there. And after performing that task, he approached me and asked me whether I would be prepared to act in his division.
And you were then appointed at the Free State Division.
That's correct.
All right. In 2005.
That is correct.
Right. That's where you still are now
That's where I still am, yes, Chief
as
Justice.
Judge President. Between your appointment in 2005 and today, you've sat in a number of courts over the years. Can you just tell us a bit about where have you been?
Thank you, Chief Justice. Whilst being a judge, I went to go and sit in the labor court because I had a keen interest in labor law. And thereafter, I was appointed to the labor, first acted in the labor appeal court, subsequently appointed as a judge of the labor appeal court. I had served 10 years because that was the mandatory limit that a judge could serve as a judge of the labor appeal court. I still act in the labor appeal court in that if the JP one calls on me to come and assist in a matter or two, I go and I assist. I have also acted in the Supreme Court of Appeal as well as in the Constitutional Court.
You've had a number of stints in the Supreme Court of Appeal,
Yes, that's correct.
but kept refusing to make yourself available for permanent appointment when you asked.
No, Chief Justice, I think it was just a matter of I am part of judicial management, and I would like to manage the province. And there were other dynamics in the province initially, which made me to decide to rather stay there. Yeah.
We'll talk a little bit about those a little later, and one of the reasons you refused to leave the division. I'll ask you pertinently about those because they're important, I think. So your relationship with the labor courts dates back to 2008. So it was the labor court and then the labor appeal court.
That's correct, Chief Justice.
In addition to acting in these various divisions of our judiciary, you've worked outside. It's ridiculous to say Lesotho is outside our borders because it's only 1.5 hours away from Bloemfontein where you're stationed. But you've worked in a few of their divisions as well.
Yes.
You mentioned that you've acted in their commercial court. You've acted. What are the other two? I can't find now.
Yes, maybe I can assist, CJ. I acted in the High Court of Lesotho.
Yes.
I acted in the Labor Appeal Court by virtue of my Labor Appeal Court experience. They have a specialized commercial court, and the Chief Justice of Lesotho then designated me as a judge of that court as well. And when they do constitutional matters, you sit as a constitutional court. I was also a judge of that court, CJ.
How many of you comprised that court?
Well, three.
Three. All
Yeah.
right. Are there
Well,
other two?
the complement of judges in Lesotho, the total complement is about 8 for the entire country.
And well, I guess that's why they rely largely on us to help them out on occasion.
Yeah.
All right. You have done a number of things. You once lectured
Yes.
at UCT, and you have done certain things with the University of the Free State.
That's correct. CJ.
What do you do there?
Well, teaching, training, or development has always been my passion. So the relationship with the UCT started when I was at the Law, Race, and Gender Research Unit. I was a director there after being one of their peer facilitators. They then asked me to periodically come and have a lecture to the first year students. Due to the racism at the University of the Free State, they started Free State 101, University of Free State, UFS 101. That was basically also diversity training for the students to see whether they can foster cohesion amongst the students. So what then happened is one of the professors who has now emigrated approached me and asked me whether I would be willing to assist. And I volunteered, and I would go and talk to the students once every term.
Well, that passion for teaching and training has spilled over to your current position now, because as a judge, you've been involved with the South African Judicial Education Institute.
That is correct, Chief Justice.
What do you do there? Training judges and magistrates?
Yes, Chief Justice, yeah, I'm also a member of the council, and I train both judges and magistrates, as well as assist Dr. Musi to draft programs, approach judges and magistrates to be trainers or developers. We identify people who have particular skills, and we then ask them to come and assist. We've had judges from the Constitutional Court as well. In fact, this time around, we will have about 3 or 4 of them assisting.
Including me.
Yeah, exactly.
So in addition to being a member of council in the SAJ, you're a member of you are a member of certain committees there, not so?
Of the Curriculum Development
Yes.
Committee. So I assist in developing the curriculum
Which
for
actually-
magistrates.
Which prepares the vision board of the institute.
That is correct.
All right. Your CV is long. You do other things in addition to training judicial officers. Just tell us about your role in the Heads of Court cluster.
Thank you, Chief Justice. At the Heads of Court, I am a member of the Judicial Accountability Committee. I am the chairperson of the Judicial Accountability Committee for Lower Courts, which is the regional magistrates as well as the magistrates. I am also the chairperson of the Judicial Operations Committee, JOC, which has now been merged with the Case Flow Management Committee. All provinces hold DEECs, which are the District Efficiency Enhancement Committees at district court level, REECs, which is at the regional court level, and then PEECs at the provincial level. The PEECs escalate all issues which cannot be resolved in the province to the NEC, but they all go via the JOC, which is the Operations Committee. We then served what must go through to the NEEC, so that the agenda of the NEEC is not long 1 and 2, so that we don't have unnecessary overlaps from the different provinces.
And as a head of court, you are also involved with the PEC and in NEC. Would you just explain what those bodies
Yes,
are?
okay. Thank you, Chief Justice. I am the chairperson of the PEC.
I only know the acronym. I always
Yeah,
forget the full name.
it's the
What's the full
Provincial
name?
Efficiency Enhancement Committee. It is a committee comprising of practically all stakeholders in the justice system. The reason why we started the PEECs was to try and see whether we can deal with challenges and blockages that impede the efficiency of the courts as an entire group, because normally what happens is there would be an inefficiency, or the courts would start late. The magistrate would say, no, but it's the police. The police would say, but it's the prosecutor. The prosecutor would say, but it's the magistrate. So if you have everybody under one roof, you can then work out a joint solution to the problem. And those in the province who are decision makers, because that's why we want the top decision makers in the province. We want the chief magistrate, regional court president, the head of the police, head of the prosecution services, well as the head of social services. We then jointly endeavor to get a solution to the problem. Sometimes we're successful, other times not. But we also deal with infrastructural problems, because we will have the Department of Public Works and Infrastructure as part of the PEEC.
And issues that are not resolved at the provincial level will naturally escalate to.
That is correct,
national
Chief Justice.
body.
They are escalated to the NEEC, but there is a sifting process, which is the JOC, and I chair the JOC.
All right. Let's see. Okay. During your time in the magistracy, you were involved in all the leadership structures there. Can you tell us about that? You started out as a member of the Magistrates Association of South Africa, and you were deputy chairperson in the Western Cape in the beginning. And then you stayed on, but later chaired that body. Was it the same body or another magistrates body?
Yes, thank you, Chief Justice.
You were chairperson of the Judicial Officers Association of South Africa.
That is correct, in the Western Cape, as well
And
as
then
nationally.
rose to become the national president of that association.
That is correct.
And you are also a member of the International Association of Judges. Are you an ordinary member there?
Chief Justice, they only take associations as members. Before I became the president of JOASA, we joined the International Association of Judges, which is a organization representing approximately 92 countries. It was formed in 1953, and its main aim is to foster and guarantee judicial independence in those countries that are member states.
All right. And you are the president of its African regional group.
I was the president for a
Just
period.
honorary now.
For a period of 8 years. I was the president.
Sorry, did you say 8 years?
8 years, yes. That is what the constitutional limit.
And are you now, or were you then in the international vice president of that body?
I was then, because I relinquished my membership of JOASA on being appointed as a deputy judge president. They still kept me. And as you are well aware, Chief Justice, last year JOASA hosted the International Association of Judges in Cape Town. And I was specially requested to assist them in organizing it because of my historical and institutional memory and knowledge about the International Association of Judges.
All right. There are many positions of responsibility you've held, both in the magistracy and here in the upper judiciary. I'm particularly interested in the role you play as chairperson, or you played as chairperson of the Commission for the Remuneration of Public Office Bearers, which ties in with your with your membership of the Remuneration Committee of the Heads of Court now.
Yes.
In that capacity, you made a presentation. You form part of the small delegation of judges who met with the executive not so long ago to discuss pressing issues in the judiciary, including its institutional independence and then many others, of course. What role did you play in that meeting?
Well,
any-
Chief Justice, yeah, that was at the meeting held on the 6th of June this year. I was specifically tasked to deal with the remuneration of judges as well as the review report that the commission wrote and to demonstrate to His Excellency the President as well as the Honorable Minister and other members of the executive that judges' salaries are currently lagging behind by approximately 33% on the most conservative configuration. That is, if only judges were given for the past 12 years CPI, nothing more, their salaries would now have been at the level of, well, they would have been better off by approximately 33%. The Minister of Finance was also there. I demonstrated to him that also on their figures, Treasury's figures, it is clear that judges are lagging behind. And furthermore, demonstrated that although the Act mentions that public office bearer salaries should be adjusted annually by the 1st of April every year, that judges and other office bearers for 3 years in the space of 12 years did not receive any adjustment at all.
Why is it important for judicial officers to be paid well?
Well, there are many reasons why it is important that judicial officers be remunerated properly. I don't think any person can become a judge with the expectation of becoming rich. It is essentially a service, but in rendering that service, a judge has a particular lifestyle and to maintain. Secondly, Chief Justice, if judges are not remunerated properly, we might just create a problem that some judges and magistrates might want to be on the take in order to live better. But if they are remunerated properly, at least you won't obviate it totally, but one can prevent it. And then there is the other issue of inflation or stagflation, as they say. Now, we know that this country is currently in a stage of stagflation where you have low growth, high unemployment, as well as high inflation. So what then happens is inflation erodes the salary of every person, including judges. So if you don't remunerate a judge properly, it therefore means that the judge's salary is actually reduced, which is an incident that the Constitution says ought not to happen. So it is therefore also a constitutional imperative that we make sure that judges' salaries are not eroded and thereby reduced.
You are one of the heads of court who have been at the forefront of the implementation of case flow management, among other measures to improve the efficiency and efficacy of the judiciary, of our courts. Has that endeavor been successful?
Chief Justice, with regret, I must say it has not been successful. But improvements have been made, especially when it comes to case management. Different provinces do it differently, but there are results, and the results are indeed positive. When it comes to the lower courts, unfortunately, one can't say the same because, firstly, there's no proper statistics keeping. The case flow management at that level is dependent on a system which is currently run and governed by the DOJ. And the magistrates seem to be saying that it, what they do in court does not speak to the system that has been devised. That system is more to assist the police. And they thought the prosecution as well. Unfortunately, the prosecution now came up with their own integrated case management system. But what I do know is the DOJ, because I had discussions with the DOJ as well as the Magistrates Commission in order to try and either do away with the integrated case management system as it currently is, or to improve it so that what the magistrate does in court and what the integrated case management system seeks to capture speak to each other.
I remember that around the time of President Mulemela's appointment as Judge President of the Free State Division, there was turmoil there. Things were not going well at all. And that you and her, over time, put in a lot of work to stabilize the division. How are things there now?
Well, see, Chief Justice, things are fine. We had another tumultuous period after her appointment, but fortunately we could handle it and we weathered the storm. What I implemented as part of team building, once a year, we go to a venue, a retreat, where we as a team of judges just talk to each other, look at the system itself, and look at how we can improve the system. At that meeting, we then agree on the way forward when it comes to operational issues, but also cohesion at the office level.
You have often given an excuse when approached to make yourself available either for appointment either at the Constitutional Court or at the SCA, that you did not want to leave the division in disarray and wanted to ensure that when you do leave, if you leave at all, you leave the division in the hands of a woman judge president. How is that going? Here you are applying for this position. Is there someone in place to take over that division competently and ably if you left?
Chief Justice, I have a very competent deputy, JP. Things have stabilized there. It is for that reason that I would agree to go and act in the Supreme Court of Appeal, because I know the division is in good hands. It's not because I know I can walk across the road and run the division. No, it's because I know the division is in good hands.
All right. I'm not going to ask you a question I asked the other candidates, whether you'd be able to work under the leadership of a woman Chief Justice, because you've already worked with a woman, President Mulemela, and worked well together.
That's correct, Chief Justice. That's correct.
Well, we may still need to ask her to vouch for you on that, though.
No, I think she has already done that.
How old are you, and how long would you serve as Deputy Chief Justice if appointed?
63, 7 years.
Sorry?
I'm 63, therefore 7 years, because the retirement age is 70.
Okay. I'm going to give you an opportunity to tell us what you understand this role for which you're applying to require, and how you would go around fulfilling the responsibilities attaching to it.
Yeah, thank you, Chief Justice.
In
With your
no
indulgence,
longer
may
than 30
I
minutes.
just use my gadget here?
And just move the mic close
I will.
to you again.
Yes, Chief Justice Commissioners, the job profile of the Deputy Chief Justice is quintessentially to support the Chief Justice by doing that which has been delegated to him or her, or in the absence of the Chief Justice, perform any function in her state. That includes furthering the vision of the Chief Justice to uphold the rule of law and to endeavor to deliver the highest quality justice to all and promote access to justice to our courts. This includes upholding the law through just, independent, accountable, and impartial decision making and ensuring accessibility to quality justice to all. It also entails protecting and promoting the Constitution and the law in order to harness the law to make sure that our society is safe and their rights protected. Although the judiciary must jealously guard against the erosion of its independence, it must, however, be accountable and uphold the highest ethical standards. Upholding high ethical standards promotes confidence in the judiciary. If the people have no confidence in the judiciary, the rule of law is imperiled. How should the judiciary then be held accountable? Traditionally, it has been said that the judiciary only accounts by way of its judgments. That, however, is a half-truth, because the judiciary must do much more than account through its judgments. It must have discernible key performance indicators, which are currently embodied in the norms and standards. I have been, in my time as a magistrate and a judge, one of the peer facilitators and developers on ethics. It's one of my strong points. So the whole notion of key performance indicators is one of the areas that I have been involved in by virtue of my membership of the Judiciary Accountability Committee, both at High Court level as well as the lower court level. Because courts must strive to achieve substantive equality and socio-economic transformation, this requires an understanding of the systemic and entrenched domination of inequality, giving judicial leadership to restore the dignity of the poor and socially vulnerable by improving their socio-economic circumstances. Substantive equality, Chief Justice, is a fundamental right and a foundational value of our constitutional democracy. All courts have to be efficient and function optimally. This, unfortunately, is currently, as I said earlier, not possible in the lower courts because they are saddled with overcrowded court rolls, which means half of the day is spent on postponements. I have spent many years in those courts and know that the problems are systemic and every stakeholder practically wants to blame the other. I know and appreciate the challenges of all judicial officers in lower courts. And therefore, Chief Justice, I would be ideally placed to assist you when it comes to the vision of improving an efficient judicial system from the high courts to the lower courts. We are currently grappling with an appropriate structure for the structural and infrastructural independence of the judiciary. The structure that is currently on the table is by and large based on the European model. France, Italy, Spain, and others have judicial councils, what is mooted for South Africa is a judicial council consisting of policymakers who are the heads of court, and then an advisory committee which consists of the Chief Justice, head of court, as well as the magistracy and civil society. In the judicial councils in the European sense, they also have predominantly judges, but also members of civil society. I served as the International Vice President of the International Association of Judges for 8 years, as I've said earlier. Simultaneously, I served as the President of the African Regional Group. The International Association of Judges is a recognized NGO of the United Nations. It is a non-political international organization bringing together national organizations of judges approved by its Central Council. The main aim of the IAJ is to safeguard and promote the independence of the judiciary in order to guarantee human rights and freedoms. Because judicial independence does not manifest itself the same in all jurisdictions, the International Association of Judges had a permanent committee looking at threats to judicial independence globally. Wherever there was a threat to judicial independence in Africa, I would sometimes be part of the team who would go to the country in distress to investigate what the problem is and to make recommendations to the Presidency Committee in Rome. It is only the countries in colonial terms, Anglophone countries in sub-Saharan Africa, that do not have judicial councils. We will be the first to have judicial council. The other countries, again, if one has to use the colonial nomenclature, the Francophone, Lusophone, as well as the Arab countries, who were all members of the African Regional Group that I headed, all use judicial councils. I therefore think that I can be of great assistance to you, Chief Justice, especially with the implementation of the structure. A single judiciary integrating all courts, including the small claims courts and the traditional courts, would be a mammoth task. I have, as a magistrate, as you probably know, fought strenuously for a single judiciary. For years, the magistracy has been talking about a single judiciary and a variation thereof, a single integrated judiciary. Unfortunately, up until now, in your tenure, there has been no inroads made to move closer to that. So I must express gratitude to you, the minister, as well as to the president for taking us so quickly to a space where we have fought for more than 25 years for the magistracy. Transformation after my appointment meant that I had to look at the judges in my division. So far, there have been 3 positions. I've filled 2. Both of them are women that are occupying those positions. I then decided with the Deputy Judge President that we should leave the one position open so that we can create a pool of candidates. Because when we looked at the applications, it was mostly males who applied. And our vision was that we need to appoint more women. Although currently the complement of judges is 8 women, 7 men. Well, there is also then the one vacancy which we have decided we will now fill, and the vacancy has been advertised. Hopefully it will be filled in October. Courts should be capacitated from the magistrates' courts right up to the Constitutional Court. As discussed with the Honorable Minister and the President, priority should be given to the Constitutional Court and the Supreme Court of Appeal. Ultimately, the promotion and maintenance of substantive equality and provision of social economic rights to all are not the only tools to transform the country. The adjudication system should be changed, as Etienne Murenik used to say, from a culture of authority to a culture of justification. This is what I endeavored to do when I was in the magistracy. I used to travel the length and breadth of this country, training magistrates on social context issues, on a culture of justification, and on how they ought to do their work. We would have workshops on, firstly, social context training, violence, gender-based violence, its different forms, as well as battering and the women battering syndrome, so that they could understand what that means. In that time, Chief Justice, we were in an era where magistrates and probably judges wrongly thought that they can objectively dispense justice without being biased. It meant that I had to, over weekends, sacrificing time with family and friends, travel to different provinces to try and explain to them that when you talk about objectivity, you must factor in the fact that you come from a particular background, and that background will influence how you judge a matter. We then had to take them through what causes bias. For an example, ordinary stereotyping, identifying with the familiar. If you are a judge who has undergone, or a magistrate who has undergone military training, and here is somebody, an accused person who has undergone military training, you immediately identify with him because that situation is familiar to you, and chances are that you might be more lenient to that person than another person. As well as cultural inequivalence, because there is this notion that cultures are homogeneous. In the Western Cape, where you have, for example, Muslims, Hindus, Christians, and other religions, but in some areas it's predominantly Muslim, in other parts it's predominantly Christian. When something has happened on Eid Mubarak, for example, and the magistrate asked, but what is Eid? And they try to explain. The magistrate said, oh, it's like our Christmas. Now it's far removed from our Christmas. So that cultural inequivalence, we used to teach magistrates about some of these issues. Likewise, we had to teach them about gender-based violence, the so-called cycle of violence, that when you see a complainant applying for a protection order, it does not necessarily mean that was the first time that it happened, because there's always or in most cases, a cycle of violence. There is the tension build up phase, then there would be the violent incident, and after the violent incident, there would be the honeymoon phase, where the man brings flowers and takes the woman out, and she comes to court and withdraws the case. And later on, the cycle just continues. And it is for that reason, I think, Chief Justice, due to the advocacy of many of the women rights organizations, that the Domestic Violence Act was changed, that prosecutors can't withdraw matters anymore. Because what they used to do is to withdraw the matter whilst the parties were in the honeymoon phase. I think a lot has been done when it comes to training. I just hope that we will keep up the momentum when it comes to the magistracy. I had the privilege of attending Professor Mervyn King's seminar on corporate governance. Although it focuses on the corporate world, I think it is equally important for judicial management because it emphasizes ethical leadership, which is very important for the judiciary, inclusivity, because if you can't be a team player, you have no business applying to be the Deputy Chief Justice of the country. You must work as a team. Likewise, you can't be a judicial leader at any level if you do not understand the concept of inclusivity and that you must work as a team. And the other point that he makes is responsible corporate citizenship. As judges, we have a duty to be responsible citizens. And then we must sustain or create sustainable value systems. In other words, when the judiciary comes up with something, it must be stress tested to see whether it is indeed sustainable. Accountability, there's no way that one can talk about judicial independence without talking about judicial accountability. And then enhanced stakeholder management. As I said, we have different stakeholders in the judicial system or criminal justice system or the justice system, civil as well. And therefore, we must look at how we manage them. And lastly, risk management. Look at what risks there are for the judiciary and try and curb that in order to eradicate it. So these, Chief Justice, has shaped my thinking. And I think I would be of great assistance to you should I be appointed to this position. I also had the pleasure of drafting the judicial wellness policy for the judiciary. Initially, there was no wellness program for the judiciary because the judiciary thought, well, if you attend a psychologist or psychiatrist for that matter, you are weak. Judicial officers don't do that because we are superhuman beings and that is not for us. I tried to, by way of the policy, to debunk that, but furthermore, made sure that the wellness, whole wellness issue is infused into all courses at SAJE. The heads of court approved the policy, and for the past 3 years, all SAJE courses has a wellness facet into it. I think this must also be done with the magistrates. There is no wellness policy for the magistrates at this stage. What we do have is a wellness policy for civil servants. As I've already said, Chief Justice, I am a member of JAC. I have served with you on JAC, and I've also served with you on the SAJIC Council. We worked well together, and I can see no reason why we can't continue to do so going forward. Thank you, Chief Justice.
Thank you, Judge President. And just to tie up a few loose ends, obtaining institutional independence for the judiciary is just one of the items on the judiciary's vision board.
Yes.
The next big task, and it's going to be a mammoth one, is the implementation of a single judiciary. Now, with your background and intimate experience, with the magistracy, do you think this is an attainable? I'm sure the minister is very interested to hear your answer. Is this an attainable goal? And would you be able to give guidance on the matter?
Without a doubt, Chief Justice, thank you. Look, it will only be an issue of scale and how to migrate the Magistrates Commission when we ultimately do this. Because currently, the Magistrates Commission is serving as the Judicial Service Commission at that level. And they sometimes have interviews for 2 months, and they interview 1,000 candidates. So the scale is just huge. We will have to think about that. Furthermore, when it comes to administrative staff, I don't think that would be much of a problem because many of them can be seconded to the OCJ. As things are now, by and large, the magistrates function under the supervision of the JP. The JP is overarchingly in charge of the entire judiciary in the province. Likewise, nationally, the Chief Justice is in charge. So the only problem I foresee is how do we integrate the work of the Magistrates Commission into that of the Judicial Service Commission. As you know, we are already complaining about the lack of resources when it comes to the JCC. There are numerous complaints at Magistrates Commission level which are still unresolved. So we will have to think about those kind of issues. But migrating them per se wouldn't be a problem because currently their salaries comes from the Treasury, National Treasury. It does not come via the Department of Justice, although Justice is the custodian of the money. It's money that comes ring-fenced for their salaries to be paid to them. The same with judges. Our salaries go to OCJ, it's just ring-fenced there, but it comes directly from Treasury. So, and then tools of trade. I also serve on the Tools of Trade Committee. Fortunately, judges and magistrates do not have a lot of tools of trade. It's basically a laptop, cell phone, router. That's all that judges and magistrates really need as tools of trade. The other issues were relating to car allowances. They already have a car scheme. When it comes to migrating magistrates from the government employee pension fund to another defined pension fund or a dispensation similar to that of judges, I think that is where the problem lies. That will have to be navigated very carefully. As you already mentioned, in my time as the chairperson of the Independent Commission for the Remuneration of Public Office Bearers, that was the main stumbling block. Because if so many members of the GEPF were to migrate out of the GEPF, they will render it bankrupt because they must then be paid all their monies. So there would be a great problem. And then a salary for life for magistrates will have to be investigated. My personal view is that for now, it is just not sustainable. It's just not viable. again, because of scale. You currently have a situation where you have 200 and something judges as opposed to 2,000 judges. And then, magistrates, pardon. And then one will still have to think, Chief Justice, about how do they migrate out of GEPF? Do they take their money, or is their money then transferred to a defined fund? Until when? And what happens if they qualify for a salary for life? So we really have to sit down and think deeply about that. That, in my view, is the only major stumbling block, Chief Justice.
All right, thank you for those views, JP. Oh, lastly, your CV does not mention that you are the judiciary spokesperson.
Yeah.
You don't
Well,
take this role seriously.
Yes, no, I
think it's
do
worth
take it
mentioning.
seriously. It's just an oversight, Chief Justice. I am the spokesperson of the judiciary, but also all parliamentary queries directed to the minister, which has something to do with the OCJ, go through me for vetting. Yes.
Thank you, Judge President.
Thank you.
I'm going to give commissioners an opportunity to put questions to the candidates. Minister, President, following.
Thank you very much, CJ. Good morning, JP Musi.
Good morning, Minister.
Thank you very much for outlining the issues. I just want to go to something that I'm quite interested in, which I also took time to study. You published an article titled Social Media and Training,
Yes.
in which you correctly extolled the virtues of utilization of social media in the courts to enhance the work of the judiciary.
Yes.
Now, in the current era where we have alternative truths, what's your view about the dangers of this in terms of the impact on the courts and also to the work of the judges? As we see that you do get quite a lot of alternative truth, or others can call it fake news, in the social media. How do you find balance? Because the courts must always have and deal with issues that are factual, but more so in terms of protecting the integrity and the image of the judiciary. Thank you.
Thank you very much for the question, Minister. Yeah, I think, Minister, we must distinguish between AI and the social media, or applied social media, as I prefer to call it these days. AI, as you know, one has hallucinations where the AI would just go haywire and give you wrong information. And we also have a situation where the algorithms for AI are made biased. Those who know about Grok, which is the AI platform of Mr. Elon Musk, a few months ago, if you say South Africa, it would just tell you how bad South Africa is and how genocidal the people in South Africa is. So it's what it is fed, and obviously judges must be very careful. The European Court for Human Rights has developed protocols for the use of AI. Although they allow it, they say, firstly, if you have used AI as a practitioner, you must disclose it. Secondly, if you as a judge write your judgment based on AI, you must also disclose it. Now, on to social media. For example, Minister, in the Free State, the court rolls are put on Twitter. Every practitioner who has business in the Free State who wants to know about the court rolls, go to the Twitter account of the court and can see that those the matters on the roll. Then there is another application that I think can be very useful, and that's WhatsApp. We've already seen how Facebook assisted with substitute service. which is a ordinary platform, but the judge in Natal used Facebook as a way of substitute service because the woman could not get hold of her husband to serve the summons. But she saw him on Facebook every day with his girlfriend, different locations, and she said to the judge, I have the account. I have his Facebook account. If I can serve it via Facebook, we can see it on his wall. And if that is done, we will at least have assurance that he has now received it. That the judge gave the order, and it was successful. The man obviously responded to what he saw on Facebook, which was a telltale sign that he received it. Now, one can also use that when it comes to maintenance, because one of the perennial problems in maintenance courts is the fact that summons can't be served on the man, boyfriend or girlfriend or husband. If one uses WhatsApp, for an example, when the clerk of the court can't get hold of somebody, most people these days have cell phones and use WhatsApp. Well, there are ways to hide the blue ticking, but many people don't. So, but if the WhatsApp is sent to the person, either by the complainant or by the clerk of the court, and the person responds thereto, there is at least evidence that the person has received that data message. And evidence relating to data messages is admissible in court. So I'm saying that there are many social media platforms that can indeed be harnessed in order to make sure that we achieve justice.
Thank you very much. Quite interesting views. In the report by BLA and FTA, they are united in saying you have limited experience to be considered. But FTA says you have limited experience in constitutional law, and they are citing a matter in which you presided over and dismissed an appeal in the matter of Dr. Malcolm Nod versus member of the Executive Council, the Department of Health in Mpumalanga. Are you able to give feedback on this, and do you think their assessment of your work and your experience is fair?
I have great respect for the BLA and FTA. Unfortunately, on this score, they got it entirely and totally wrong. It just boggles the mind how somebody who is a judicial officer for plus minus 33 years is said to have limited experience. Secondly, the Nodia matter is a very interesting matter. The application was not dismissed. What happened is, it was during the time of HIV and AIDS. It happened in Mpumalanga. The Dr. Nodia was already qualified, and he wanted to go and work at Rob Ferreira. What the MEC then did is she did not want to allow him to go and work at Rob Ferreira. And the only reason why she did not want to allow him is because he was an AIDS activist. During the trial, it became clear that there's a shortage of doctors. He is one of the junior doctors who is a shining star, but for the fact that he was one of the doctors who said people must get ARVs, he did not get the job. And I said, well, that is wrong, it's discriminatory, and I made an order that he be paid. So there's no application that was dismissed. They have their facts totally wrong.
If I can do follow up on that one. JP Musi, and thank you for that and clarifying that. But following that as well, there's been an issue that was raised in the public domain about your work allocating what the public has said, a junior judicial officer, to a critical matter that led to the attack on NPA and its credibility. And I'm linking this to, again, this work that there's reflection on your work. Are you able to reflect on that?
Yes,
Do you regret doing that in such a critical case, which obviously now has been overturned, the appeal has been won?
thank you for that, Minister. They say in law, context is everything. I think the same must apply to other disciplines as well. Because what has been bandied about in the newspapers and by certain pundits is exactly that the lady who did the matter is inexperienced, so was inexperienced. But what is the context here? Firstly, all serious commercial crimes in this country are done at the regional level. Last week or this week, a matter of Transnet, it's done at the regional court level. The matter, if I may mention his name, of Mashele Koko, that was removed from the role, was done at the regional level. But let us, strangely, and you know, it's what normally happens to women out there. All of a sudden, she's nameless. She has no history. They just say an acting judge. Nobody say, this is Nompumulelo Kusha, who started off in the Department of Justice as a prosecutor in 1999, who has been a magistrate, who has been a senior magistrate, who has been a regional magistrate, and has 20 years service, more than some of the judges in my court, as a criminal court practitioner. That is not in the public domain. But fortunately, I anticipated the question. I have a CV here. So that they don't mention. They just say it's an acting judge. But more than that, Minister, we all get it wrong. You know, I can't understand why people think that because an acting judge got it wrong, therefore it's a cardinal sin. And that when a person is appointed as a judge, you magically become endowed with all the knowledge and you are flawless, you don't make mistakes. We make mistakes. The system is like that. The system functions with mistakes. Even seasoned judges, well-experienced judges, have in the past made mistakes with Section 174 and other issues. And it was corrected on appeal or not corrected on appeal. That is why our system has those checks and balances. It does not help then to just put a narrative out there and say, acting judge, acting judge. Because that is exactly what happens, you know, that's, they tend to make sure that the person vanishes. Because if people can dig a bit and look at who the person is, they would then understand that, oh, this person has 20 years service in the criminal justice sector. So, no, as a judicial officer, by the way, because she was appointed in 1999 as a prosecutor. So, Minister, I think the problem is people do not, when they write, give context to what they write, because they want to promote a particular narrative. I've been upset on appeal with my experience as a judge.
Thank you very much, Judge Musi.
Thanks.
Thank you,
Thank you,
Minister.
Minister.
President Mulemer.
Thank you very much, CJ. Good morning, JP Musi.
Good morning, President.
How are you?
I'm well, and you?
I'm fine, thank you.
Good, good.
JP Musi, you are aware of the provisions of Section 10 of the Superior Courts Act. I know you are aware, which provides that expenditure in connection with the administration and functioning of the superior courts must be defrayed from monies appropriated by Parliament. You are aware of that provision,
Yes.
aren't you? You have been a head of court for quite some time, and you are also aware that during the 2018-2019 Judiciary Judiciary Day for the 2018-2019 financial year, the former Chief Justice Mogoeng, mentioned on that occasion that a particular organization had offered the judiciary 600 million, approximately 600 million for court modernization. You recall that?
Yes, I recall it.
Yes, and he rejected the offer because one of the things that he mentioned is he did not want to be seen to be participating in what could be termed state capture. Now, being aware of these provisions, but also being acutely aware of the lack of resources, financial resources within the judiciary, if after your appointment, if you were to be appointed, the CJ were to say to you, develop a policy on the judiciary's acceptance of financial contributions from donors, what, in the interests of transparency, would you include in that policy? That's the first question. The second question is, what steps would you take to make sure that anyone and everyone who is interested in assisting the judiciary in one way or the other is aware that there is a certain kind of assistance within certain parameters that the judiciary can accept? Thank you.
Thank you, President. Look, should I be asked to do that if I were appointed? Firstly, I think there should not be solicitation by the judiciary. But if somebody wants to make a donation to the judiciary, there are obviously risks, and it's a question of risk management. One, why is the person giving the money? Who is the person giving the money? What interest does the person have in giving the money? Would the person be a litigant in our courts in future, or is the person already a litigant? And then when it comes to transparency, like we have a register of interest, we will then have to develop something like that for the OCJ. Because if, for an example, the European Union wants to assist the judiciary in South Africa by giving us an amount of money, by giving us an amount of money, the risk is very, very low. But if it is one of our retail stores or our banks in the country who are always litigants in our courts, unfortunately, the optics will not be right. So it is something that you'll have to scrutinize the donor, the motive behind the donation. But I personally see nothing wrong in us accepting a donation because we are in dire financial straits.
Yes, thank you very much. In the context of competing priorities that the judiciary is faced with, what would you prioritize in the event that the long aspired for goal of judicial independence is attained? The challenges that I'm referring to are well known to you as a judge president serving in the Heads of Court cluster. Thank you.
Thank you, President. Firstly, I think it depends on the size of the purse. But what is crucial to me now is digitization of all the courts. Because, for example, my court does not yet have case lines. The bandwidth, there was a problem with the bandwidth. Fortunately, I heard last week that that problem might be a problem of the past, but then there must be training and so forth. I don't think the Northern Cape, the Northwest Province, has digitization. So you now have a situation where the one court is in the Stone Age and the other one in the 21st century. So we need to prioritize that for all courts. Then, courts function very, very difficult without proper support staff. So the courts must be capacitated with proper court staff. That, in my view, would be, for now, the priorities, especially for my court. On that one as well, you have a situation where some judges, president, have office managers, others don't. And when you say, but why is it that I'm a bigger division than that division, I don't have an office manager? You're told, JP, there's no money. But I need an office manager, JP. We understand, we hear you, but we don't have any money.
Thank you very much, JP.
Thank you.
Thank you, Commissioner Baloyi. You may pose question.
No, I didn't have my hand up.
Oh, okay, I see your name here. Yes, you may, Mr. Commissioner Nkweto.
JP, good morning.
Good morning, Commissioner.
I've been asking candidates about their philosophical approach to the Constitution, informed by the biggest problem the country faces of racial inequality and the fact that we are the most unequal country in the world by Gini coefficient, according to the World Bank. And whether, in fact, there is anything lacking in the theoretical approach adopted by the Constitutional Court to socioeconomic rights in particular. That's the context. Do you think that there is a gap to the reasonableness standard adopted in Grootboom? And if so, how can that gap be filled in interpretation?
Thank you, Commissioner. Look, the Grootboom matter was obviously decided based on the progressive realization of socio-economic rights. Because although at the time we just moved into democracy, we decided to have justiciable socio-economic or third generation rights. But the reasonable standard seemed fine at the time, but later on it seems to be a bit too differential. In that the courts have all this power in terms of the Constitution to make sure that the state complies with its duty to promote and give people their socio-economic rights. With the courts then went and took an approach that says, well, let us hear what the government says. We don't want to decide for them as such. Let's hear what they say, and what if what they say is reasonable, then we will accept it. But the Constitution, as I understand it, it says legislative and other means. So is the standard of reasonableness the standard that we should stick to now, or should it not be the best effort standard? In other words, have you done your best to make sure that these people's rights are promoted, protected? The matter of
Sorry, JP, I don't want to interrupt you, but I need us to just get the ground rules of the conversation. At the time of the adoption of the standard, the debate that was pushed by some academics was around minimum core,
yeah,
that you have to first lay a normative base, which is called minimum core. The court rejected minimum core. But 25 years later, the socio-economic situation of black people is worse than it was 25 years ago. But they have rights under the Constitution, under Section 26, access to adequate housing. Now, you've made one critique, which I think is helpful, that the standard is too differential. So that's what I'm trying to build with you. Well, how else should Section 26 be construed if it's not via the lens of the so-called reasonableness standards, where we've rejected minimum core?
thank you, Commissioner. The point I'm making is, now that we have a problem with the reasonable standard, because it's too differential, shouldn't we up the ante? And I'm saying that it should not be a question of the government or the state saying, well, this is what we have, this is what we reasonably can do, or this is what we reasonably did. I think the courts can do more and say, well, this that you are giving us might be reasonable, but is it your best effort? There's a case
we must
of
reject reasonableness into a best effort standard.
I'm thinking, I'm just thinking about it now, that maybe you must do your best and you must come and prove to the court that you have done your best under the circumstances. Because that is also something that is normative, because socio-economic rights are always context specific, because it depends on what the socio-economic right is. So I really think that you would recall the matter of Lindwe Mazibugo, the water issue, where the court also used the reasonable standard. And it turned out that a few months later, the meters were installed, and people were charged for water, and they were not given what they asked for, and which was sufficient water. But on the other hand, there was the very robust approach, although no standard was set. But I think that is a question of, you did not do your best in the Model Club matter, also here in Gauteng, in Davidson, where informal settlers went and settled on a farm, and there were skirmishes, eviction orders, and nothing helped, basically. And the court then said, well, you did not do your duty as the city of Benoni. Now you will have to pay the farmer, and these people will then be the tenants of the farmer, but you pay until you get them alternative housing. So it's in my view, a more robust approach to the issue.
Yes, look, I don't want to have a dialogue, but I'm still unclear about what you say should replace the standard, if you accept that the standard simply does not meet the crisis of inequality that South Africa has. But let me ask you a different question about, again, interpretation, because that's your primary function as the deputy chief justice, is about interpretation of the law. The common law, especially in contract, is entrenched in South Africa. It was brought to us by the Dutch people and the English people, and then apartheid made it worse. Now you've got a constitution that is seeking to fashion a new law for the new South Africa. But at the same time, it is constrained by the common law. Now, on contracts specifically, I just want to understand your theoretical framework, whether or not you take the view that a clause in a contract can be declared to be unlawful on the basis that it is unfair.
Thank you, Commissioner. On the first question first, I said the preferred standard is best effort. On the second one,
Well, I was not sure what the content of that standard is. That's what
okay,
that's what I was talking
oh,
about.
but it's okay.
It
Let
sounded
me go
be
to your
as
second. Let me go
abstract
to your
as-
second question.
yeah, sounded
Look-
as abstract as reasonableness. But anyway,
Section 39(2) leaves no holy cows. Now, it seems to me that it is a matter of how the courts interpret it and how the courts cling to pacta sunt servanda as a principle. Instead of saying, well, we are now in this new constitutional era with new ethos, new values. If a contract is blatantly unfair, it cannot be consistent with the Constitution. And that clause should then be able to be declared unconstitutional or excised from the contract, depending on what influence it will have on the entire contract. But the whole notion of pacta sunt servanda, I think it has its limits and probably it had its day.
so these cases of the Constitutional Court, like University of Johannesburg and Predwin, all of which refuse to declare contracts unconstitutional on the grounds of fairness alone, you would depart from those.
I think I would. I think I would.
Thank you, JP.
Thank you.
Follow up, CJ. CJ, follow up. Oh, sorry.
Thank you, CJ. Good morning, Chief Justice.
Good-
Sorry, I apologize, JP.
Thanks for the
mixed two.
promotion, but no thanks.
I mixed the two. JP, I'm so sorry. I apologize. Good morning,
Good morning,
JP.
Commissioner.
I want to follow up in relation to both issues that Commissioner Ngokaitu has put to you.
Yes.
The first one was the Grootboom related question around core minimum content versus reasonableness. And your answer was that reasonableness is too differential and you propose a best efforts standard. Now, can I just understand which interpretive approach do you use to arrive there? Because the Constitution expressly incorporates a reasonableness standard.
Well, the Constitution says all that is, the state must take progressive steps to realize those rights.
It says reasonable,
reasonable,
legislative, and
yes.
other measures, yes.
But if you want to test that objectively, the state will have to bring evidence, and then there are further issues. Are the legislative means taken sufficient? Two, do you have other means that you could have used to make sure that the rights of these people can progressively be realized? You see, if it's just reasonableness, as the Constitution says, and we leave it at that, as I said earlier, it's to my mind very differential. And secondly, although the reasonable standard is there, if you have not taken your best effort, it's unreasonable. I think by way of reasoning one can get there to say, well, but you have not done your best. So if you have not done your best, it's not reasonable. And therefore, the measures that you have taken are not sufficient.
So you're still applying a reasonableness standard? You're just
I'm
giving
saying-
different meaning to a reasonableness standard?
Yes, which is a higher, let me say, different meaning, but a higher meaning, putting a duty on the state, because that is where the duty lies. In order to realize these socio-economic rights, the state has this duty. We've decided on going the route of justiciable socio-economic rights because we want to transform our society rapidly. I mean, there are countries, just our neighbor, Lesotho, they have socio-economic rights, but the constitution clearly says it is not justiciable.
And
But
then
we took a conscious choice.
you didn't answer the question around core minimum content, whether you believe there should be a core minimum content in a socio-economic right.
Look, my view is there should be, but it should not be blanket. It should not be with regard to all socioeconomic rights. We must look at the context of, and maybe even content of the right to get there. But yeah, but I agree that there should be there.
But isn't a core minimum content the opposite of a context approach? I mean, you're saying that there should always be a minimum level of a right, irrespective of the context.
Well, it's not necessarily mutually exclusive, in my view.
Commissioner King?
Good morning, JP.
Good morning.
I'd like
Commissioner.
to take up your understanding of how the Constitution could assist judges in relation to a matter that you've looked at carefully, which is remuneration. As I understood your answer to the Chief Justice at the outset of your interview, you said that judges were being paid 3% behind, and I didn't know what your comparative was, but I think you were saying that had CPI been applied consistently, as opposed to not having been applied for the 3 years you referred to, where there was no adjustment at all, then the amount now would be 3% lower than if judges' salaries had kept up with inflation. Did I understand you correctly?
Thanks for the question, Commissioner. Unfortunately not. The point that I made was we made a comparison of the salaries of judges between the year 2012 to 2024, because the last review for the salaries of all public office bearers was done by the former Deputy Chief Justice Museneke. And at that time, the judges, magistrates, and all other public office bearers were satisfied. But thereafter, the salaries of judges were not increased concomitant with CPI or any measure higher than that. So, if you take CPI year on year from 2012 to 2024, you will see that the difference of what a judge gets now and what a judge would have received had CPI been applied, the difference there is 33%.
You're saying 33%?
33, yes.
All right, now that I understand the facts, how would you use the Constitution if you were given the appointment as Deputy Chief Justice to ensure that this is rectified?
Yes, that is somewhat of a difficult question, because I do not think that the DCJ should get involved in litigation on the issue. But assuming that judges, Judges Association or individual judges want to take the issue on, one, there is an argument to be made that the fact that judges do not receive an adjustment every year, as the legislature requires, means that effectively their salary is reduced. Because the reason why the Act says there must be an adjustment every year is to make sure that the salary is in line with inflation. One. Secondly, a judge's salary and benefits may not be reduced in terms of the Constitution, but if inflation goes up and nothing is done by the government, there is a tangible, clear signs that people, all people, and I'm not saying exclusively judges, all people now earn less because of inflation. Then effectively you have reduced the judge's salary. Then you can use the Constitution to say, well, the Constitution says you may not reduce. What you have done is effectively to reduce my salary and benefits. Yeah.
Thank you.
Commissioner Marumahai?
Thank you very much, CJ. I will abandon my follow-up on Commissioner Ngulatovi's question. I think I should follow up on Commissioner Kane's question, because I think I should not take the JP back. We rather move forward. Good morning, JP.
Good morning, Prof.
On the issue of remuneration, when the CJ was leading you raised an important factor, that part of the considerations in relation to magistrates, your view, if I understood you correctly, and please correct me if I'm wrong, is that you are thinking about advocating for magistrates to move away from the government employees pension fund to a defined benefit fund. Did I correctly understand you?
No, Commissioner. What I said is it would be difficult to migrate them from the GEPF to a defined fund, because if they all move from the GEPF, it might even render the GEPF bankrupt, because it's a lot of money. It's going to be a lot of money. So, but the anomaly there is that they are not public servants, and the GEPF is government employee pension fund. They are not government employees. So somehow we must think of getting them out of there. I've not yet advocated anything at this stage.
My concern with that is the government employees pension fund is a defined benefit fund.
Yes.
And when one looks at it, it has the backing of the PIC and the government, and the benefits are defined. What would be the motivation to move magistrates from that is the largest pension fund in Africa in terms of assets and members? And what would be the motivation for moving magistrates from such a well-oiled fund?
Thank you, Commissioner. Firstly, they are not government employees. They don't belong there. They are judicial officers. Secondly, although it's a big fund, it's not the only defined fund. We have Alexander Forbes, that can easily handle their pension, because Alexander Forbes also handles the pension of your political office bearers. So it's a question of principle more than money and the sustainability of the fund itself. Because otherwise, they can even think of creating a separate defined fund. But that is what I said. That is the only big problem that I foresee. It's what to do with that, with the pension fund.
That was my follow-up, CJ. Thank you.
Your hand was up anyway. You might
yes.
as well take this chance.
Oh, thank you very much, CJ. JP, I have two questions that I want to debate with you. The first question that I have for you is, and I know that you, before I even ask, it was quite a pleasure to read your judgment, as versus Rabaka, where you really dissented on a very minor issue as to how rape victims should actually be handled. I think that was an excellent judgment in many ways.
Thank you.
On the question of criminal law broadly, when one deals with Section 11 of the Criminal Procedure Act and the bail procedure generally, it seems to me that there is misunderstanding in South Africa as to what the purpose of bail is. And we often see communities being agitated when somebody has been arrested, who they accuse of having committed a heinous crime, to say that this person should not be granted bail. On the one hand. On the other hand, we see high-ranking politicians who are able to arrange bail as and when they get arrested and be able to get courts, magistrates or judges and place bail and actually get out on the same day, even when they are accused of Schedule 5 and 6, which is not an ordinary thing that happens for ordinary members who are remanded for investigations and they will have to come back after a week for a formal bail application. On that note, what do you think the legal fraternity, lawyers also included, can do to better explain the bail processes so they can be understood as to what is the purpose of bail and how bail can be seen to operate fairly across the board?
Thank you, Commissioner. Firstly, the commission of crime is a highly emotional thing. The commission of serious crime towards children, women, for example, is very emotional. And there are people who would want to influence the judicial process by protesting outside as their way of saying, well, we think this person should not get bail. But in those matters, I think, firstly, when it comes to the presiding officers, they must start off by explaining properly that bail is not a punishment. Bail is just a way to secure the person's attendance at court. But unfortunately, we go into legalese, which is another impediment to access to justice. Because the minute that we talk Section 6011 and we put all the requirements there, people get lost. But if we make it plain that bail is not a question of punishment, when it comes to the prosecution, those people out there are normally people who protest against the accused person. The prosecutor, I think, has a duty then to go out there and to say, well, there will be a bail application, the magistrate will decide, I will do my best to ensure that the person does not get bail. But should the person get bail, it is not yet the trial. It does not mean that he is now going to be released. But the people out there normally say, since you mentioned rich, it is better to be rich and guilty than to be poor and innocent. Because if you are poor and innocent, you'll stay in jail for a long time pending your trial, even 2-3 years. But if you are rich and guilty, you can get bail quite easily. That's unfortunately what the perception and optics are out there.
Thank you, JP. My second question, it is in relation to the processes of court, which I'm trying to think about quite broadly nowadays. And I want to ask you in line with condonation applications, particularly in the context of applications for leave to appeal. And in particular in relation to the Supreme Court of Appeal and the Constitutional Court. When you look at the rules of the Supreme Court of Appeal, there is this theme of a month that is always running through that you have to do something after a month, which is not quite clear as to what a month is. Because when you look at the rules of other courts, they give you court dates as to how you should operate. Now, what then happens when you get an order from a lower court and that order is granted today by a judge, but by the administrators, it is given to you after a week or 2 weeks. And then your date should be operated from the date the judge granted the order, but you move slightly to the desired date from the date when you received it, and you make an application for condonation. When the higher court considers that application, is it lawful or is it permissible for a court then to grant costs against you when you fall within the required date, either 16 days constitutional court or a month in the Supreme Court of Appeal from the date when you received the order? Is that something that is constitutionally permissible?
Well, thank you, Commissioner, for that. I think not, because if in your factual account, it is common cause that you only received the order on day X, and between day X and your application, that is less than the month or the 20 days or whatever else it is, why should should you be marked it in costs? I don't see any reason. I don't think it would be a proper exercise of discretion under those circumstances.
But can a discretion be exercised in favor of granting you costs?
Granting cost against you.
Against you, the applicant, yes.
Conceptually, yes. But would it be right? No.
Okay. Thank you very much, CJ.
Commissioner Hassan?
Thank you very much, CJ. JP, nice to see you again. I know that we most recently saw each other with the interviews for the SAJE CEO, which we'll be returning to at a future date. I just want to pick up on one or 2 points, CJ. And it relates to what the minister had initially raised, but just in terms of the noting process. JP, I want to interrogate the Nulani matter a little bit further, and I'll mention a few things before I get into my question. The first is that we're all quite well aware now of the SCA, who found that the acquittal, particularly on the count of fraud, and I'm quoting now from the SCA, was baffling, and that the High Court had made numerous errors of law, etc. It also talked about, and again quoting, a failure of justice that erodes public confidence in the criminal justice system. The SCA basically ordered that there should be a retrial. But more importantly, they found that there was in fact a prima facie case of fraud, money laundering, etc. Now, JP, I acknowledge that you are not and were not the judge that presided over the case. And you've pointed out that it was an acting judge who's at the core of the issue. But given the magnitude of this case involving state capture, and we'll note, I mean, the public knows this as well, this was one of the first cases of the state capture era that has come to the point of prosecution and therefore has significant public interest and outcome. So my first question, JP, and I'm concerned about how you answered the minister. Was it not ultimately your responsibility as the head of the division to ensure that such a matter was allocated to a judge with the requisite experience, skill set, and that you should have exercised appropriate oversight? And how do you reconcile this with the kind of leadership accountability that is expected from someone seeking national judicial office?
Thank you, Commissioner. As I have said, the acting judge concerned has more experience in the criminal court than some of the judges in that division. So if I appointed, for an example, a judge with 2 years experience on the bench, who comes from a background doing only civil matters, one, would it have made a difference? 2, when we appointed this judge as an acting judge, we knew about her experience. We've seen some of her matters on appeal. We have spoken to the regional court president, because I don't appoint people from the regional court without making sure that I discuss it with the regional court president. So at that stage, we were satisfied that she is appropriately and suitable, so appropriately qualified and experienced and suitable to deal with the matter.
You see, my concern, JP, is that the Supreme Court of Appeal has made it very clear, on one hand, that the manner in which the case was managed in your division was inadequate, and I mean, they were quite clear. Some of the wording that they used was very, very strong. I mean, there's even other points, if you look on the case, in which other political analysts, members of the public, Amabungani, and many other very well-respected institutions spoke to the High Court judge's pronouncements unfairly embarrassed the National Prosecuting Authority, and this is the important point which I'm leading to, demoralized courageous prosecutors fighting to restore faith in South Africa's justice system. JP, I'm very concerned that we're not looking at the core of the issue here. Because while we might want to isolate the Nulani case, the reality of the matter, and I'm going to pull from here very particularly, the asbestos corruption matter, it's another high-profile state capture case. The NPA has taken a very extraordinary step where they requested that the case be heard from a judge outside of the Free State Division. And this request was widely interpreted as a signal of concern of either perceived bias or a lack of confidence in the independence and integrity of the provincial judiciary, right? So I don't think we can just sweep this under the carpet by saying these were the credentials of an acting judge who was clearly wrong, one, but I'm very concerned now because the entire reputation of your division is at stake. The country is feeling a further failure of the criminal justice system. The NPA has actually been exonerated by the SCA, and you are now appearing before the JSC, asking for us to consider you to be the Deputy Chief Justice. And I don't think you're appreciating the gravitas of what we're trying to understand and ask you here. There are 62 million South Africans who feel that your division failed them, who feel that corruption or soft spot was taken on them. Let me say it like that. And I'm very concerned that perhaps your leadership of the division, what is the standing of it in the eyes of this national institution? Because it's not just about the Nulani case, it's about something far broader.
Thank you, Commissioner. Look, the asbestos case, the issue there was not an issue of bias. The NPA is on record. They mentioned the security of the judges. They are on record that they would want a judge from outside because they fear for the security of the judges of the Free State. At the time, I was in the SCA, but in consultation with my deputy, we decided no, there's no substance, because if you want a judge to recuse him or herself, you don't play it in public, you do it in court. Then you go and you file a proper application for the recusal of the judge. But what the NPA did is the Director of Public Prosecutions in the Free State decided to write a letter to the DJP and made this request. Firstly, when the DJP received the request, there was no indication that the other parties involved in the matter were copied in. And secondly, there was no legal ground for the application.
Okay. JP, I'm trying to understand a different point. When there's a fire in your house, what do we do? How do you address the problem? And I'm worried here that there might be a perceived lack of accountability. I'm worried about the perception of the judiciary in fighting corruption. And I'm worried because many South Africans are going to watch this interview, and they need to know that if you become a potential DCJ, Deputy Chief Justice, that you have the requisite skill set, backbone, and ability to directly take on corruption through the judiciary. We know there are many sites in which we are fighting corruption. But I'm very concerned that, again, as the leadership of the division, you're not taking accountability for where we are now.
Thank you, Commissioner. Commissioner, you must be mindful of the fact that those cases are not the only two corruption cases that were in the Free State. There were many, many, many other cases. And they were dealt with swiftly and justly and properly. There was no outcry about them. And the asbestos case, the prosecution wanted to forum shop, which is a fundamentally wrong thing for the prosecution to forum shop. Now, what you don't mention is they even said to the DJP, well, we want assessors appointed to assist the judge, and we want to choose the assessors. Now, how can you choose the presiding officers in your own matter? So it's not a matter of not taking accountability. It is a question of when one looks at the entire picture, one sees that there was actually nothing about the asbestos matter, that the furor that they wanted to create, because ultimately the matter proceeded in the division.
JP, let me ask this more directly. Do you believe you exercised adequate oversight as the head of the division? And how do you account for that systemic failure that followed such a critical allocation decision?
When you say adequate oversight, I don't have oversight over cases. When you say allocation, yes, maybe, but you must also bear in mind that judges have other matters, firstly, and secondly, those matters are dealt with by different judges at different stages. But as a general proposition, yes.
Okay.
May I just follow up, CJ, with your permission?
No, there is another, people must not just jump in. There is another follow-up that already raised her hand, then it will be you.
Thank you, CJ.
Minister?
Thank you very much, CJ. Judge JP Musi, just to confirm what you are saying, are you saying that when NPA requested the recusal of the Bloemfontein judges was on the basis that they were worried about the safety of the judges? Is that what you say?
That is
Because
what
that's not what my understanding and the letter I have seen, it's not even confidential that I would have seen in my capacity as a minister, but this is what has been in the public domain. The letters by NPA were circulated publicly. The response letters by then the acting JP was circulated publicly. And the issues that were raised there was mainly around the biasness and or perceived biasness, that they were feeling that the cases were never going to be seen properly. Maybe if you can explain that. And then there's another part which also you spoke to as you responded to Commissioner Hassan, that I just want you to clarify. You are saying to the commission that there are many other cases, so and therefore your understanding in terms of the relationship, what the NPA would have done there shouldn't have. Maybe if also you can explain how, as JP in the Free State, managing the relationship with the stakeholders that are critical as such as NPA.
Thank you, Minister. Firstly, the letter just mentioned the accused persons and said there's a premier involved and there are other highly placed officials involved in the case. But what they then honed on, and if you see, if you look at the letters, you'll see. Firstly, the point is made that the judges from the Free State are in a similar position than judges from any other province when it comes to this issue, and that they have not mentioned any bias at all against any judge, and that is why the DCJ the deputy JP expressly said, well, if you feel that they would be biased, bring an application. And secondly, when it comes to the safety, judges in the Free State will similarly be imperiled like a judge from outside. That is basically what the letter said. And they have made no allegation about bias against a particular judge or a group of judges. No, they just mentioned that the accused, who the accused are, and they are high profile accused. So one can probably infer in that they meant all the judges will be biased.
The second part of that question,
Which was, Minister?
the issue of the relationship, because from what you are saying
No.
and what would have been articulated publicly by NPA as well does seem to suggest that there are issues of relation management. And that's why I'm asking, as JP, how is the relationship management with critical stakeholders such as NPA in ensuring there's effectiveness of our work in that province?
Minister, we were also baffled. As I say, I was at the SCA then. When the DJP told me, we were totally baffled that the DPP could do such a thing and send such a letter without even requesting the parties, because that is the point that we made. The DPP could have requested the parties on both sides to attend to the DJP's office and then discuss the issue before leaking the document to the press. And that was the issue. So the office of the Judge President and the office of the DPP in the Free State never had issues. Never ever had issues.
Okay, thank you. Maybe just to put in record, the letter does say that the results for request for recusal is on the basis that many judges had dealt with asset forfeiture application in respect of about 7 accused that were appearing before that court. Thank you, CJ.
Yeah. Yes, Minister, but that does not say they were biased. Because you can deal with an asset forfeiture matter and deal with a criminal matter. But I understand what you're saying.
Commissioner Lekganye?
CJ, thank you so much. Good morning, JP.
Is it a follow-up?
Yeah, it's a follow-up.
Oh, okay.
Good morning, Commissioner.
Yes. Look, I listened to you when you responded to the question when the minister asked you for the first time. And correctly, when you explained, you said that the judge that you have appointed has been there since 1999. Is that correct?
Yes, correct.
Yeah, so mine will be that if you have made this decision to appoint this judge, like any coach who has options on players that must be fielded. Mm-hmm. And then the SCA comes and makes trenchant criticism on serious omissions of law against that judge. And then you appear before the Judicial Service Commission and questions are being fielded here before you for your response. As a person who holds office that must be seen as an office of unimpeachable integrity, do you find it difficult to say, in our line of work, there will be mistakes that happen, and this is how the mistakes can be corrected? Is that difficult? I mean, when you made a presentation here, you spoke about accountability, you spoke about everything that goes with your office. Do you find it difficult? South Africa is listening to you. Do you find it difficult to say against public expectations? The public did not expect the Supreme Court to go and reverse a judgment that was made at a provincial division. But it's not the findings of the public, it's the findings of a superior court. Serious omissions. And you are the person who has an opportunity to come before the Republic now. It's your opportunity, it's a penalty moment. What do you say?
Thank you, Commissioner. I've already said, as the JP, I allocated the matter to her, but she got it wrong. And the system is of such a nature that we all get it wrong. The fact that a judge is overturned at the SCA level is not the end of the world or does not signal the total incompetence of the judge. But the judge got it wrong, and many judges get it wrong. That is why we have courts of appeal. But lastly, let me say this. I agree totally with the Supreme Court of Appeal. I agree with it. In fact, if you look at the judgment of the Supreme Court of Appeal, you will see I disagreed on one point and one point only. I agree fully with the Supreme Court of Appeal.
Lastly, do you think in your response, was it proper for you to say other experienced judges have gone through similar experiences, their decisions were reversed by, should that be the standard way of responding? Do you think such an iteration was proper for you to make it before the JSC to say other experienced judges have gone through similar experiences?
Thank you, Commissioner.
Or do you regret making such a statement?
Commissioner, the point that I made was that judges get it wrong. And that's exactly the point that you say. You field a player, but the player on the day is useless, does not score. And I'm saying, well, yes, I fielded this player. This player disappointed me. But the system is of such a nature that if a player does not perform, it's not the end of the world, because there are appeals and processes like that. And I even said I was upset on appeal, because it's not a badge of dishonor, really. Because even in our higher courts, well, the highest court in the land, the Constitutional Court, you'll find differences by judges. Sometimes they're even split right in the middle. The one sees it that way, the others sees it that way. So it was not to traduce the character of any particular judge or judges. No, definitely not.
But do you agree with me that we learn every day and
Yes.
then we correct?
Yes, 100%.
Thank you so much.
Yes.
Commissioner Mangen?
Thank you, CJ. What is this? Still a morning. Good morning, JP.
Good morning, Commissioner.
Look, allocation of matters is a management issue.
Yes.
So what is at issue here, as I understand it, it's the decision that you took to allocate a matter to the judge when it was of national importance, so to speak. Now, having listened to the questions that have been posed to you by the Minister, by Commissioner Hassan and Commissioner Al-Khanyan, and given the fact that hindsight is the best insight to foresight, were this situation to arise again, would you decide in the manner that you decided?
Thank you, Commissioner. I would probably not.
Thank you.
All right, commissioners, before I allow Commissioner Toby to follow up again, I don't think it really takes matters anywhere really to flog one question for 20 minutes or even longer. A candidate gives their answer. If they flunk, they have flunked. We make of it what we will. Otherwise, we'll be here until tomorrow. Carry on, Commissioner Toby.
Thank you, Chief Justice. I will stick to that. No, it was just a matter of concern that I had that you've accused the NPA of having leaked the communication and whether or not you want to revisit your statement on that, because I think an accusation coming from the Judge President of such impropriety, because it can be a criminal offense for the NPA in certain instances to leak information related to an ongoing trial, whether you want to revisit that statement or not.
Yes, thank you, Mr. Nkaitobi. You will note in the communication that the Deputy Judge President wrote, that allegation is also made because when she received the letter from the NPA, the press already had the letter and the press already called her. And she spoke to the DPP to say, well, but how does this happen? I get the letter per hand, but the press already knows about it. And that is where that inference comes from. So there's no direct evidence. It's probably inferential reasoning, but they were told in no uncertain terms. And it was also part of the communication between the DJP and the DPP. So yeah, but maybe because it's inferential reasoning, and no, there's no concrete evidence, it's maybe an unfortunate statement to make.
Yes, but I mean, you stick with the accusation that they leaked that letter.
Well, they did not refute the allegation when it was made. So that's the point.
I've lost my list now. Commissioner Breitenbach?
Thank you, Chief Justice. Good morning, JP.
Good morning, Commissioner.
I'm afraid I'm not yet done with New Lane. I'd like you to explain, if you would, your view on the allocation of cases in your division. I would expect the most difficult and complex cases to be allocated to the most experienced and competent judges, and that the most complex cases be done by yourself as the head of that division. When you appointed this acting judge in the New Lane matter, did you appoint her specifically to deal with that matter?
No.
Or had you had the opportunity to observe and judge her work in previous acting stints?
Yes.
I'm not
But
done.
not
I'm not done yet, so just wait for the question, please. You're stating that the acting judge in question has 20 years of experience is really more concerning than comforting in these circumstances.
Yeah, thank you, Commissioner. The problem is you judge somebody by his or her previous work, the experience, the fact that the person is functioning in a criminal court for 20 years. So, and then everything goes pear-shaped, yes. You're 100% correct.
Yes, I'm interested in your allocation of cases in your division.
Oh, no. Firstly, as I have said previously, the fraud matters emanating from state capture matters are routinely done in the regional courts. This is a regional magistrate. So the idea was, well, it's a criminal matter. She has all the criminal experience. The matter may be allocated to her. But as a general rule, when it comes to opposed motions and matters like that, except for long criminal matters, I don't do long criminal matters due to the fact that I have other commitments and other work to do. Short criminal matters, yes, those I do myself. And furthermore, all pre-trial conferences in the division are done by me or the DJP.
Thank you. Then you say reasonably glibly that the acting judge got it wrong and judges do get it wrong. Well, yes, I agree. Of course, no one's perfect, also not judges. But to get it so spectacularly wrong, to fail to apply the simplest elements of fraud to the facts, that's problematic, especially in the light of the excoriating nature of her judgment. So what will the consequences be in the wake of this judgment of the SCA? This acting judge is still on the bench. Will something be done to offer some form of training, something be done to improve the way she deals with, even despite 20 years of experience, improve the way she deals with matters?
Firstly, she's no longer on the bench. She was just an acting judge. She has been subjected to further training at the South African Judicial Education Institute. She is part of the Bridget Mabandla Aspirant Judges training, which is a training that spanned over a year.
Thank you.
Commissioner Godser?
Thank you, Chief Justice. Good morning, JP.
Good morning,
The
Commissioner.
Free State has long been associated with severe governance failures and the large-scale misuse of public funds. Now, in that context, there is a perception that the provincial judiciary has at times been overly deferential to the executive, particularly in politically sensitive matters. One example, which is often cited, is the court's refusal at the start of the asbestos matter to hear an urgent application to halt the first asbestos contract payment, which arguably enabled irreversible financial loss and, had it succeeded, might have prevented the now seemingly ill-fated criminal prosecution of the contract's beneficiaries. How do you respond to this perception? And as the Deputy Chief Justice, how would you promote a culture of judicial independence that resists undue deference to executive authority?
Thank you, Commissioner. Firstly, well, it is a perception. I don't know where it comes from, but there might be a reason for the perception to be there. When it comes to the specific case, that case was case managed by me, and it was given to a senior judge. There were about 3 applications in that matter, and the NPA was successful in all 3 of them. Mr. Magashule brought applications. They were unsuccessful. And currently, the matter is being dealt with by one of the senior judges there. I don't know where the perception comes from. And in many other cases, as I earlier said, there have been convictions. Yes, there have been a slew of problems in the Free State, and there have been convictions.
You say you don't know where the perception comes from, but in this specific application, it was brought as an urgent application, and it was removed from the role as not being urgent, and it subsequently led to massive financial losses.
Thank you, Commissioner. Well, that was in the civil court. Yes. And the judge exercised a discretion to remove the matter based on the fact that it's not urgent after hearing the parties. So, yeah, I don't know whether it would be proper for me to comment on the judge exercising her discretion.
Yeah,
And that was a senior judge in any event.
The second part of the question was, how would you, as the Deputy Chief Justice, promote a culture of judicial independence that resists undue deference to the executive authority?
Now, clearly, all judges, all judicial officers ought to be impartial. They should not be subject to interference by any person, regardless of that person's standing and station in life. So obviously, when I become the DCJ, that will be one of my tasks to make sure that I foster a culture of judicial decisional independence. And it's something that I've always done, even in my time as a magistrate.
Thank you, Chief Justice.
Commissioner Matolojev.
Thank you, Chief Justice. Good morning, JP.
Good morning, Commissioner.
I mean, having had the discussion you had with all the commissioners regarding some of the matters that concern them, mine is just to find out, you say you have been, you are a spokesperson for the judiciary.
Yes.
South Africans are very unhappy with what is happening with our constitution. They don't believe in our constitution anymore. What do you think can be done, especially as a spokesperson, just to bring them back into the fold, to make them understand how it works and how it affects them? Thank you.
Thank you, Commissioner. I earlier spoke to the Minister about social media, for example. In many European countries, the judges of courts, as well as the administrative personnel of the courts, are allowed to block, to explain. Maybe what we should do, because the Supreme Court of Appeal, as well as the Constitutional Court, issue media summaries. We should probably look at a more innovative way to get those media summaries to the public. Maybe Twitter, Facebook, so that the public can read what happened in a matter and how a particular decision was taken, and what clauses in the Constitution were utilized in order to get to that decision.
Commissioner Lefanyane, your hand was once up. Are you covered?
No, I'm okay, CJ.
Inkos Nkonyane.
Thank you. Morning, Chief Justice, and morning, colleagues. Morning, JB.
Morning, Commissioner.
Yeah, you mentioned that the right to equality is fundamental in South Africa, and I agree with that exposition. But is customary law, stroke indigenous law, equal to Roman Dutch law in South Africa? If it's equal, I would like your brief motivation for your response. If it's unequal, same, I will request you to tell us. Thank you.
Thank you, Commissioner. The problem with indigenous or customary law currently, and why it lags behind, is there is not yet a legislative foundation. Because, as you know, the Act is there, the Traditional Courts Act, and it emphasizes constitutional values, it emphasizes equality, but it is not yet operational. On the other hand, the Roman Dutch law, due to our colonial history, has been mainstreamed over the years. And for an example, in Elkscore versus the Rechterveld community, there the court said that the problem with our indigenous law is it is not always in writing. It is a law that is dynamic, but it is always relayed from generation to generation. So I think those led to that part of the law not being treated equally, because otherwise we would by now have had this law, the Traditional Courts Act, implemented. And you'll also note that the section on traditional leadership in the Constitution is probably the shortest chapter. There's no real elaboration on it. But when it comes to section 39 sub 2, I don't think any law can be said to be above another, because there it's clear, any legislation, the common law, or any other law, including indigenous law, should be brought in line with the object, spirit, and purpose of the Bill of Rights. So yes, my view is, unfortunately, that the Traditional Courts Act is not yet there, but the law itself can be taken to the highest court in the land. And there's no way that it would be said that this law is supreme to this one. As long as it stands constitutional master in terms of 39.2, it's fine.
Thank you, JP. I hear you. But I also heard you, which is my second question, and the final one. You indicated that the apex court correctly is the constitutional court, and the lowest is the small claims court. My question then to you, according to did I understand you correctly, therefore, to mean that traditional courts do not exist in South Africa?
No, Chief. I think you misunderstood me, Commissioner. I expressly said the apex court is a constitutional court up to the traditional courts, because in terms of the envisaged legislation, matters from the traditional courts can go to the magistrates court. It can even go to the small claims court, for that matter, if it's referred there. So there's no question about it. I've always been in this space. In fact, in 2020, I delivered a paper in Nairobi, Kenya, about indigenous law. And if my memory serves me right, you were also supposed to be there, but unfortunately you didn't make it. So I'm quite au fait with customary law and indigenous knowledge systems.
Thank you, CJ. I have no further questions.
Commissioner Mangena, do you still want to ask your
Yes,
question?
thank you, CJ. JP, I must commend you for highlighting the issue of the mental wellness of judges, because they work under difficult and stressful conditions. Their wellness deserves to be taken care of, and a job well done on that front.
Thank you.
Yeah. The question that I would want to ask you relates to your CV. I had you respond to the CJ that you are an admitted attorney.
Yes, I am.
When were you admitted? Because when I looked at paragraph 6 of your CV, it tells me that you completed BUris in 1985, and then you became a prosecutor in 1986, and then went through the ranks up until your appointment as a JP.
The Act gave recognition to magistrates and prosecutors who have been magistrates or prosecutors for a period of 5 years or more. And all that you had to do is attend the 6 months law school at night, and then you could go and write. That's exactly what I did.
Okay, thank you, CJ.
Commissioner Balui?
Thank you, CJ. Good morning, JP.
Good morning, Commissioner.
Yes, JP, President Mlimela asked you for your priorities if you were to be appointed. What would be your priorities? You listed, at least I've got two. The one was digitization of all the courts, and the other, as I understood it, was that courts must be supported the same. And I think the example you gave was that you find some JPs have got an office manager, others do not have. So those are the two. What I did not hear is what difference does that make if you get that? What does that make to the customer of judicial services? Because on the face of it, it looks like nice to haves. It makes the lives of judicial officers easier. But for the listening public, I would imagine the interest is, what does that have to do with me? A related issue to that was the discussion about remuneration of judicial officers, that we need them to be better remunerated. Now, I accept that there is no debate or controversy that all three should happen. But what does it have to do with the delivery of services to the public? And I asked the question, sorry to be long, I asked the question because among the issues that we hear, it's the workload, shortage of judges, the long rolls, and we a single judge in Tata in February, in unopposed motion, they have 143 matters allocated to them. The same situation in April. And that didn't feature in your list of priorities. And it's a matter of concern on the face of it, that you don't seem to be concerned about matters that have an impact on the quality of services received by the public.
Thank you, Commissioner. The digitization project, I don't think it is a self-serving one. It is actually one of the major forms that we can harness to achieve access to justice. Because if somebody there in the rural areas, deep Transkei, wants to serve papers in Bloemfontein, it becomes much easier if you do it digitally. Likewise, if you have evidence that you want to file via case lines. So to me, that's not a nice to have. It's actually an imperative. It's an indictment that there are courts that still don't have that. And when I referred to the capacitation of the officers, it is exactly so that if the office is better capacitated, you need more staff. When you have all these new things coming, you need more personnel to deal with it in order to make sure that things are filed properly. You will probably know in many courts that you have been, you will be told the file is lost. You can't get the file, or one clerk must place the file. So then when the things go to the JP's office, there is somebody there that can deal with it. So those are the two issues that I specifically honed on as part of the whole access to justice concept. Because, if we look at the rules, the client's attorney must have officers within a particular radius. That will be something of the past if we can file electronically. There might not even be a need for correspondence if we file that way. So that, in my view, is a major priority.
Thank you. A second question also arises from answers that you gave earlier, and this was, one of them was about funding, accepting funding. The judiciary rather accepting funding. Now, and I understood how you answered it, but I want to take to that as one of the issues, the use of acting judges, especially practitioners, legal practitioners. There's often a concern that you have the same practitioners who sit and act, they later come back to appear before the same judges. So what you alluded to earlier when you spoke about funding, whether we take money from people who are later going to appear before the court, it seems there should be the same sensitivity to using legal practitioners to act because they are going to be appearing before people who last week were their colleagues on the bench. As a matter of policy, what are the issues that you think we should be alert to, the judiciary should be alert to, both in respect of accepting funding from sources other than parliament, but also utilizing especially legal practitioners as acting judges? And for me, this is a question about appearances of partiality or impartiality of the bench.
Yeah. Thank you, Commissioner. Look, unfortunately, the first one is very systemic. It has been happening over the years that practitioners act in a particular division and the next week they are counsel again. That has unfortunately been the case. But I hear you and I accept your point that maybe we should rethink all that. But the funding part, I do not think that we should receive funding even from individuals as such. Because you just never know what might happen in future. And that is why I said we must be very circumspect when it comes to accepting money. If the donor is, for an example, from Europe, well, unfortunately, it can't be America anymore, from Europe and those places, and it's a reputable organization that works with judiciaries or with the judiciary, I don't think it would be a problem. The International Commission of Jurists would sometimes offer scholarships to judges or invite judges to conferences and say to the judge, if you don't have the funding, we are prepared to sponsor you. In that case, the judge must obviously disclose it. But secondly, the risk is minimal that that organization will appear in our courts. But the judiciary should make sure that there should not be that perception of bias. I agree with you totally.
Thank you, CJ. Thank you, JP.
Thank you.
Commissioner Trollip?
Thank you, CJ. Good morning,
Morning.
JP. I'm going to take the lead from the CJ and not flog a dead horse about the New Lane matter. But I do want to just make a comment, and that is that I did detect initially there was some dogged defense of the acting judge, despite the fact that the SCA ruled that there was a misapplication in law on 4 counts. That's a concern to me. But JP, in your response to a question from the Chief Justice about judges' remuneration, you said that ethics is an area of keen interest to you. It was your passion, and you mentioned Mervyn King's presentation around corporate governance and ethical leadership. And then you said that appropriate remuneration would prevent judicial officers being tempted to be on the take. Do you believe there are judicial officers that are on the take? And secondly, do you think that judges' remuneration is suitable to be able to attract the best possible legal minds into the judiciary from the private practice?
Thank you for that question. Maybe let me answer the second one first. That's one of our recurring pleas to the executive, to the commission, that we cannot attract suitably qualified and experienced counsel to come to the bench because the salary is just not attractive. They will tell you it would be an act of insolvency. I mean, even when they come to act in the courts, they say, well, it's basically an act of insolvency. The first one, look, there are numerous cases at the level of the Magistrates Commission of judicial officers who have been charged with corruption and being on the take.
You have finished, Commissioner Trolley. Commissioner McClung?
Thank you, CJ, and good morning, JP Musi.
Good morning, Commissioner.
My question emanates from your presentation on the point you made about your involvement in efficiency enhancement committees, particularly at PEEC level, and also regarding the inefficiencies in lower courts. Now, with the right to a fair trial comes the right to have your matter be brought before a court of law and be expeditiously dealt with. And there are safeguards legislatively, such as your Section 342A in the Criminal Procedure Act, and also to a large extent, the efficiency enhancement committees are there to ensure that the right to a fair trial is realized. But the reality is that there are incessant systemic inefficiencies in lower courts, such as overcrowding of roles, late starting of matters, unwarranted postponements, and so on and so forth. What other measures do you think can be put in place to alleviate this challenge? Thank you.
Thank you, Commissioner. Because this is a system, it's a chain. One must look at where it actually begins. What is its provenance? Sometimes the police arrest too quickly. Because if the police arrest somebody, they take that person to court. Even in cases where they can issue a warning for the person to appear at some future date, they take the person to court on the next court date after holding the person for the duration that they are allowed to. But on the other hand, you have a situation where, as you would know from legal aid, you have one legal aid attorney in a court, and that legal aid attorney walks around with 10 files because he has 10 cases in that court, or she. And what then happens is, if one trial must run, the 9 must be postponed. That's unfortunately how it is. Now, it impedes access to justice. You also get a situation where the prosecution would not be ready to proceed with the matter, but the defense is not told beforehand. Everybody waits until the day of the trial. And it's only on the day of the trial that people run around and they want the matter postponed. So half a day, as I said, half a day of the court day is just gone. And then when they start the trial at 2 o'clock, they can't finish the trial. So I think what should actually be done is that the presiding officers should take more charge of their courts. Because if the presiding officer does not take charge of his or her court, anarchy reigns. That's the problem.
Thank you. Thank you, CJ.
Any more questions, colleagues? Commissioner Muimang?
Thank you, CJ. Good morning, Judge President.
Good morning, Commissioner.
Just two from my side. The first one relates to the non-appointment of permanent judges to meet the demand of the caseloads. In certain areas, this has been defined as the judiciary that is in a state of crisis. And this shortage of judges, to a larger degree, results in the delay in handling of cases. So the question that I want to pose to JP is, in view of the constraints and the constraints around resources, but more than that, the issues around the judicial posts that exist across the divisions. What will your proposal be in a view to one, to ensure that a formula is formulated to sort of come up with a workable solution to address these vacancies, which obviously leads to crisis around access to justice. The first one, the second one relates to the point that you raised around the remuneration of judges. I know that between 2014 and 2019, JP was the chairperson, yes, of the Remuneration Commissions Committee. You took that from Judge Willie Seriti, and the current one is former JP Leo. It will be important just to get a sense from yourselves where the crisis is, because as the chair of that commission and committee, there will be concrete proposals that will make, which will attempt to address the areas that we raise around the non-adjustment of the salary of judges. Thank you. Thank you.
Thank you, Commissioner. Look, the first point on the non-appointment of judges, every division has a establishment size. Like for instance, in the Northern Cape, it would be 7 judges. Now, if one judge retires, resigns, or just by way of attrition leaves, that position is vacant and the JP can fill it immediately because it's a funded position. Unless, of course, the JP has other plans with that position, with that vacancy. A formula, it's difficult to really work out a formula, because what happens is the judge president of that division looks at his or her needs and then fills a vacancy or not. But the major thing is, periodically, at least twice a year, the Judicial Service Commission Secretariat requests the judges, or judges president, to indicate the number of vacancies and whether the vacancy should be advertised. Now, it's then incumbent upon the JP to make sure that the vacancy is advertised. So the second issue relating to...
Maybe before you go to the second issue, there will be certain divisions which are similar in terms of population size, caseload, and economic activity. Will the approach that suggests that where there's a crisis, probably the sharing of those allocation, can it work, particularly in busy divisions, to address the crisis?
Yes, look, it will always be a crisis if a court functions predominantly on acting judges. But to work out a formula, I don't think so. I can't, for now, perceive of a way in which one can formulate a formula unless there is a proper study, work study, looking at the number of judges, the number of cases coming in, population size, and then say, for this division, it ought not to function with a percentage of 30% plus acting judges. But it needs professionals to go and investigate it. It will be very difficult for me, where I'm sitting now, just to make a judgment call, unfortunately. And on the second one, look, the commission always has competing interests. As the judges go there and make presentations to the commission, so too do members of the parliament and members of the of the provincial legislatures. Likewise, we have traditional leaders, we have local government councillors, but the purse is small. And we sometimes, as the commission, have made, I'm sure you know, recommendations that across the board, public office bearers should receive 6%. It goes to the presidency, and then a few months down the line, we get a government gazette that says nothing, 0% for everybody across the board. So, and then the constant refrain would be, but there is no money, there is just no money, unfortunately.
Thank you, JP. Thank you, CJ.
That was the last question of your interview, JP Musi.
Oh, thank you.
I just want to thank you for accepting the President's nomination for this position and for indulging us for half a day. Is there anything you wish to raise with us before we let you go?
No, CJ, I think I would be remiss if I don't thank the President for nominating me and deeming me worthy for such a high office. And I would want to extend my gratitude to him, as well as to yourself, the Minister, all the commissioners here. Thank you.
Thank you, sir. You may
Thank you.
go.